Hello, everyone. Welcome to another episode of QuickIP. Today, we've moved and now we are at the bus stop of patent law. And we will only in patent law be dealing with the subject matter requirement for patentability and the requirement for patent protection. So we'll just briefly refer to infringement, to revocation, to other things that happen within patent law. But these two topics are just the focus for our purposes in the intellectual property law module. So how does the patent system work? And what is the patent system and how does it work? Remember, some of you might be familiar with, and if you're not familiar with, you should totally check it out. But in South Africa, there was a time that we had some HIV AIDS epidemic in the country. And within that epidemic, it really just basically showcases the way that the patent system could operate. Because in that environment, the fact that we've gone from that epidemic to a better environment where people are now able to live longer and fuller lives, even when they are infected with the HIV virus. It's because the people that are in the pharmaceutical industry came up with antiretroviral drugs, medicines that could basically considerably slow down the growth and spread of this virus in someone's system. Remember again the COVID-19 pandemic that the world is even now just slowly coming out from in many parts of the world. Remember that it was when vaccines were discovered, and even not just vaccines, when doctors began to see how various treatment options could work and various drugs that could help in treating people who have been infected with the COVID-19 virus. These are all evidences of how the patent system works in terms of protecting the inventions and the innovation that are behind the manufacture and production of these vaccines, of these medicines. In the digital aspects of things, in terms of technology, there's currently an artificial intelligence system called DeBus, which has invented, or there's the claim that it is the inventor of a patentable product that was registered in South Africa, that obtained patent registration in South Africa, but not in other jurisdictions. We will talk about all that in class. So in this environment is just to tell us that there is such a thing as a patent, and when you have those patent rights, you are able to protect inventions from exclusively from people using it, commercializing, making products based on that invention. So how does the patent law work? The patent is basically a document that if one gets when they successfully file an application for patent protection. They are issued with a patent, which then recognizes that they own rights, exclusive rights to inventions that have been disclosed in that patent document. So now, what are the sources of patent law in South Africa? You're talking about the Patents Act of 1978. You're talking about the Patents Amendment Act. This Patent Amendment Act basically introduced definitions of genetic resources, indigenous biological material, and traditional knowledge, and makes mandatory disclosure requirements for revocation of it. So it basically sort of like improves aspects of the patent law. You're also referring to the TRIPS agreement, You're also referring to the Patent Cooperation Treaty and the Paris Convention as well. We'll deal with all that in fuller details in class, but these are the sources of patent law in South Africa. What are the administrative institutions in South Africa that relate to, that deal with patents? You're talking about the Patent Office, the Registrar of Patents, the Commissioner of Patents. The Commissioner of Patents is an aspect of the High Court that hears patent cases. Then there's the Register of Patents, or the Patent Journal, where you can find information about patents that have been granted in South Africa and patents that are about to be granted in the country as well. What's the subject matter requirement for patentability? The way that most patent law works is that it will tell you that inventions that satisfy specific criteria would be granted a patent. But in some jurisdictions, for example, South Africa, inventions are not defined. So you will not see what an invention is, but it will tell you what would not constitute an invention under patent law. And it lists things like discoveries. And you would see when we look at the requirements for patent protection why discoveries are not considered inventions. Scientific theory, mathematical methods, literary, dramatic, musical, or artistic work, or any other aesthetic creation, because those ones are already protected under copyright law. A scheme, a rule, a method for performing a mental act, playing a game or doing a business, no patent protection. Computer programs, no patent protection because it's not considered an invention. The presentation of information. If you put together information, these are facts. They are already there. You've not taken it forward in terms of patent law for you to enjoy patent protection. Perhaps if the information is presented and expressed in an original manner, fixed in a form, then you're maybe talking copyright protection, but definitely not patent. So what are the requirements for patent protection? The requirement is that you want a patent provides legal protection for a new and industrially applicable invention. So going back to what is not an invention, a discovery is not new because it's been there. We know it's there. It's just that you maybe it's hidden to you or it's hidden to the world, but you just discovered it. So it's not an invention. It will not satisfy the requirement of being new and industrially applicable. A scientific theory might not be industrially applicable, or even if it is, it might not be new or it might not involve an inventive step. So if you have a new invention and an industrially applicable invention, it has to be one that has been brought about as a result of inventive steps. You have to show us that you've moved forward, that you've advanced that field in a new way. So an invention is only considered to be new and based on an inventive step if the same idea has not been expressed in writing, orally, or practically, or in any other way, anywhere, immediately prior to the priority date of the invention. We'll get to that in the next class when we talk about the specific requirements for patent protection or the eligibility criteria for patent protection. But if you can show that your invention is new, that it involves an inventive step, that it involves it's an industrially applicable invention, and it has to be new because you've not expressed the same idea around the invention somewhere else, then we're talking that it's possible for you to obtain patent protection. Let's look at a patent application so that you just see some of the aspects that one has to deal with. We'll look at it in fuller details in class, but here, this is with the DBOS artificial intelligence system invented food container that I talked about at the beginning. So here you would see the the application number and all that, you will see the person applying for patent protection. This is the person, Taylor, Stevens Taylor. Taylor is the one applying for patent protection. And the inventor for this particular invention is listed as Debus. The invention was autonomously generated by an artificial intelligence. And this is the agent that is assisting the applicant to file the patent application. This is the priority data. These are the dates that this invention has been, that they want to claim that this is when we put this, the invention or the knowledge behind this invention within the system, where we can say this is the priority date, this is the date we are claiming that from this date we are the ones that you should look at in terms of the novelty of this patent. And this is the abstract, where you basically summarize what this invention is about. And those are some of the things that the patent office will be looking at to be able to say, okay, this invention satisfies the requirements of the statute and the patent should be granted. So it describes this invention as a container for use, for example, for beverages, has a wall with an external features and internal wall, basically describing the invention, because it is that description that you have on the patent document that we will use to judge whether infringement has taken place or not. It is that description that we will use to judge whether your patent is new. We'll look at that description, we'll look at the claim that you're making, that I did this, I did that. We'll check those things that you said you did against those requirements of novelty, of inventive step, of utility, of whether it's actually an invention, a patentable invention. So those are some of the things that you have to satisfy for you to come to this point where you are granted a patent over that invention. So again, look at this, the patent application that we're talking about, and the claims and the various aspects of the patent application, the claims, the abstract, the description of the invention and all that. You put that out publicly. So it's there. The patent filing is there. This one that we have placed on this page, you can get it online from Patent Scope, which is a platform operated by WebPro. There are various patent databases where you can search inventions and patents that have been granted. Even in the case of South Africa, if you go to the CIPC website, you will see that there's a search tool where you can search for certain patents. So you have all that information and it's there. It's useful because during the patent period, people who can read the patent document can see what innovations and what inventions are out there. The same thing when the patent expires, because the duration of the patent is for 20 years in many jurisdictions, including in South Africa. So when the patent expires, anyone can use that information to produce products covered by that invention, because now there's no longer patent protection covering the invention. Also, during the patent period, it informs one of new inventions that could allow you, for example, to approach the patent owner to say, I can manufacture generic versions. Let's say it's a pharmaceutical patent, so a patent that is covering a medicine or pharmaceutical product, which was what happened in the HIV epidemic in South Africa, where generic medicines manufacturers approached the people who were making who had patents over this antiretroviral medicines, and said, we would like a license so that we can manufacture generic versions that are cheaper for people to purchase, and so that we can reduce the number of deaths from this dreaded virus. So that's sort of like the benefits of the patent disclosures and the fact of how it interacts with the public domain. We'll stop here and we'll have more details in class. See you then. Bye.